and Journal for Catholic Legal Studies, and a fellow for the Mattone Center for Law and Religion. I would like to start by thanking the people who made this event happen. First, thank you to Professor Movsesian and the Mattone Center and the Mattones for collaborating with the Journal of Catholic Legal Studies for this symposium. Second, thank you to Teresa Dugan, Claire Pollicino, Lori Hertz, and the entire special events team at our school for their incredible work and effort on this event. There's no question that they're the reason that this event is happening tonight. Third, thank you to our esteemed panelists, Michael Moreland and Michael Helfand, for giving us their time and expertise on this issue. Finally, thank you to Abby Drummond, our journal's editor-in-chief, who works tirelessly to make sure that this journal runs so smoothly. Thank you to Tiffany Depwest, our symposium associate managing editor, and the entire Law Review for always showing up and putting in effort to make this happen. It is now my honor to introduce Jelani Jefferson Exum, the law school's 10th dean, and inaugural Rose DiMartino and Karen Sue Smith Professor of Law. Dean Jefferson Exum brings the experience and insights of a distinguished lawyer, professor, scholar, and leader to her vital work at St. John's. Since starting in June, she has met many of you at events and programs and shared her vision for partnering with our extraordinary alumni community. With her leadership, we will build on Alma Mater's 100-year tradition of educating lawyers who make their mark in and beyond the legal profession while serving the greater good. Together, we will carry St. John's Law forward into its next century of excellence, prominence, and impact. Welcome, Dean Jefferson Exum.
Thank you very much. Well, good evening, everyone. I'm very, very happy to be here and to have the opportunity to welcome you again to this symposium. But I'm really here to congratulate both the Journal of Catholic Legal Studies and also the Mattone Center for Law and Religion for the work that I know goes into pulling together a symposium like this one. So you should all be very proud of yourselves. This is truly something that's very important to our school. I've been dean at St. John's Law for now that's April 10 months now, and eventually I'll stop counting, but you know it's still fun to do that. But early on in my time at St. John's, it was very clear that the Center for Law and Religion was really one of our most prominent and active centers, and so I'm very grateful to the Mattones for their support of this program, and also to Professor Movsesian for his great leadership as director of the center. And then I also came to learn about the Journal of Catholic Legal Studies, and I'm so proud that it does exist at our school. It's very important to our mission and to our identity, both as a Catholic institution, but also as an institution with a mission to have rigorous scholarly dialogue across various perspectives, and to really focus on important and impactful issues. And this one that will be discussed today at today's symposium is certainly of constitutional significance and of just real impact to real people. And that is what we do at St. John's Law. That's the type of education that we give to our students. And so the center and the journal are so very important to that. I'd like to thank, in addition to Michael Mattone and to Professor Movsesian, the students who've worked so hard today to put this together, as well as our panelists. So thank you for spending your time and giving us your expertise. I look forward to learning a lot and to joining in the discussion with all of you. Thank you so much.
I guess that'll work. Welcome everyone. So I guess people know who I am. I'm Mark Movsesian. I'm the director of the Mattone Center for Law and Religion here at St. John's. This is the third symposium that the Mattone Center has sponsored in partnership with the JCLS. It's a wonderful thing to do, and I'm very pleased it's become an annual event, and I look forward to tonight and future iterations of this. I'd also like to recognize Michael Mattone, who's here, for whom the center is named, in honor of whose generous gift, his and Denise's. The center is named. Thank you so much for joining us this evening, and not only this evening, Michael actually comes to most of our events, and so thank you very much for doing that. I also want to recognize one of our board members, Judge Richard Sullivan, who also comes to many of our events. He's here too, so thank you very much for coming, Rich. And thank you to Dean Exum and the students. So, our symposium tonight addresses a case that is currently before the Supreme Court, Oklahoma Statewide Charter School Board versus Drummond. It's set for argument later this month. The case involves a public charter school in Oklahoma called St. Isidore of Seville Catholic Virtual School. You can probably pick it up from the name. St. Isidore is a Catholic school. And so the fact that Oklahoma has chartered it as a public charter school raises some very interesting questions under the Establishment Clause and also the Free Exercise Clause. Not only interesting questions, but also deeply divisive questions that we'll debate this evening. Before we get into all that, though, I'd like to introduce our panelists, both of whom are old friends. Michael Helfand, to my right, is the Brendan Mann Foundation Chair in Law and Religion and the co-director of the Newt Barr Institute for Law, Religion, and Ethics at Pepperdine University, and also the Florence Rogatz Visiting Professor at Yale Law School, from where he joins us this evening. An expert on questions of church and state, Professor Helfand's work has appeared in numerous law journals, including the Yale Law Journal, the New York University Law Review, Duke Law Journal, and many others. He also writes for the Wall Street Journal, the LA Times, and the Forward. To my left is Michael Moreland. Michael Moreland is University Professor of Law and Religion and Director of the Eleanor H. McCullen Center for Law, Religion, and Public Policy at Villanova University. An expert on constitutional law, torts, bioethics, and religious freedom, he's frequently sought for commentary at national and international conferences, in the media, and before Congress. He's published articles in legal, public policy, and medical journals, including the Notre Dame Law Review, the Georgetown Journal of Law and Public Policy, and Law and Contemporary Problems. He's also written essays for numerous scholarly collections, including titles published by Cambridge and Oxford. And he's been a visiting faculty member at Notre Dame and Princeton. Okay, so what's our roadmap for tonight? I'm going to state the case and introduce the main issues, and then the two Michaels will offer their thoughts, which I think will differ somewhat, and then we'll open it up for a discussion. Okay, so I'll state the case. As I say, St. Isidore of Seville Catholic Virtual School is a Catholic school. It forthrightly asserts that it wishes to operate as, quote, a genuine instrument of the church and participate in the church's evangelizing mission. St. Isidore I'm quoting a statement from the school, St. Isidore fully embraces the teachings of the magisterium, which it seeks, quote, to incorporate into every aspect of the school, including, but not limited, to its curriculum and co-curricular activities. The school's two founders are the Catholic Archbishop of Oklahoma City and the Catholic Bishop of Tulsa. The school has a board of directors of between 5 and 15 persons, not more than 2 of which may be non-Catholics. In short, St. Isidore is a traditional, indeed I think we'd say very traditional, Catholic school. But whereas most Catholic schools are indisputably private, St. Isidore is, at least as a formal matter, public. St. Isidore has a state charter, which is given by the State Charter School Board. Under Oklahoma law, charter schools are expressly denominated as public schools, which are operated by contract with private organizations. They're unusual in the degree of freedom that they have with respect to some aspects of curriculum and personnel, but as a formal matter, they are public. Crucially, charter schools like St. Isidore receive their total funding from the state, which funding allows them to admit students free of charge. Now, typically, when the Oklahoma Charter School Board contracts with an organization to establish a charter school, the state insists that the school be non-sectarian. But the contract with St. Isidore waives that requirement. Instead, the contract states that St. Isidore has the right to freely exercise its religion, its beliefs, and its practices, which is, one presumes, the whole point. If St. Isidore could not operate as a Catholic school, it wouldn't seek to operate at all. Okay, that's the background. In this case, the Oklahoma AG sued in state court to have the charter school board rescind the contract with St. Isidore as unconstitutional. And I should say, just as an aside, there seems to be some oddity of Oklahoma administrative law here. Why can't the governor just order the school board to do that? Why does there have to be a lawsuit? I guess the charter school board is independent in some way. It seems to be a matter of Oklahoma state law. Anyway, just a kind of footnote. The Oklahoma Supreme Court ruled that St. Isidore violated, or I should say the contract with St. Isidore, violated both the state constitution and the federal constitution, specifically the Establishment Clause of the First Amendment. And the Oklahoma Supreme Court also held that denying the charter to St. Isidore would not violate the Free Exercise Clause of the First Amendment. Okay, so the Supreme Court then granted cert in the case on two related questions. First, whether St. Isidore is a public entity, a state actor, or, as the school claims, a private organization contracted with the state. That's the first question. And the second question is, assuming that St. Isidore is a private actor, whether denying it a charter because it is religious violates the Free Exercise Clause. And as I say, SCOTUS will hear argument in the case this month and presumably decide by the summer. Briefing just ended on Monday. Okay, that's the background. Now, just to tee it up for our two panelists. On the first question, is St. Isidore a public school? It seems to me that if St. Isidore is a public school, then it's pretty clear this is an Equal Establishment Clause violation. Whatever the outer limits of the Establishment Clause, the state can't fund indoctrination in a religion, Catholicism in this case. This seems to me a lot more than a public school football coach praying on the 50-yard line after games. The argument that St. Isidore is a public school seems pretty strong to me, given that the way the statute is written and also the realities of how charter schools work. But I know that at least one of our panelists disagrees about that. So maybe St. Isidore should be understood as a private actor. By the way, there's a lurking federal courts question here. I have a couple of federal court students in the audience. Normally, the Supreme Court would defer to the state high court on the proper interpretation of state law. And here the Oklahoma Supreme Court has declared that under state law, St. Isidore is a public school. That, I think, would normally settle the matter, but the Supreme Court doesn't defer to a state court on, quote, an antecedent state law question, where doing so would interfere with federal constitutional rights. We'll see if that becomes an issue here. These issues, although they're fun for federal courts professors, they're important for federal court students, they're not really showstoppers. If the court wants to hear the case, the court's going to hear the case, and I think that's probably what's going to happen here. Okay, that's the first question. Assuming that St. Isidore is a private actor and not a public school, then the question is, would denying it a charter violate the Free Exercise Clause? And here, I think, the answer is going to turn on whether the court thinks there's enough of a filter between the school and the state. So I know our panelists will talk about this, but the basic principle is that where a state makes benefits available to the public, it can't deny benefits based on the religious status of the recipient or the fact that the recipient will use the benefits to advance a religious mission. This has come up in a number of the school funding cases like Carson and Espinoza, which I know our panelists will address later on. But an important factor in this case is, it seems to me, the presence of indirect funding as opposed to direct funding. So in cases like Espinoza and Carson, the state provided financial aid to parents, some of whom chose voluntarily to send their kids to a religious school. So there was a filter there. If you think to the very first Establishment Clause case, the very first time that the court applied the Establishment Clause to the states at all, it was a case called Everson, which involved bus fares that parents were using to send their kids to parochial schools. But again, it was the parents who were deciding. And in this case, the funding is going directly to St. Isidore by virtue of the charter. It seems to me that will make a difference, but maybe some of our, at least one of our panelists, I think, will disagree with that. So we'll hear what the argument is. So there are a lot of issues here, including some that I haven't mentioned, but I think it's time to turn it over to our panelists. So the way we'll run this is, I'll first turn to Michael Helfand, who will give his statement, and then Professor Moreland, the other Michael, will give his statement, and then we'll open it up for some discussion. Okay, so Professor Helfand, please. Let's turn it on. There you go.
Perfect. First of all, thank you to Mark.
Yeah.
putting all of this together, the students who are putting this together, St. John's Law School, the Mattone Center. For those who don't know, I too have a small little law and religion center, but like the Mattone Center is the center of centers. So like there was a gathering this year, like where all the directors of law and religion centers came to figure out what we're supposed to be doing, and that's where it got hosted. So it's wonderful here to be here with you. Thank you very much for all you do for the field. Second, it's great to hang out with the other Michael. I don't know if we disagree about anything, that's the problem. So we're gonna find out. This is like, I'm trying to figure out like how provocative to be in order to make sure we disagree about something. I think I'm gonna end up saying things this evening that I don't actually think, but that might be true. So that's gonna be Michael. Okay, good. You know, this case, there's something that strikes me a little bit peculiar about it. This kind of, as Mark identified, there's this kind of state action, antecedent state action question. What are we looking at over here? We have an entity that is chartered, authorized, funded by the state, but operated by a private entity. And so how should we think about it? Should we view this as a public school or as a private school? And depending on where you end up on that question, you end up down two very different constitutional rabbit holes. I think conventional wisdom runs something like this. If we think of it as a state actor, it's a public school, a state actor, and as a result, we would subject it to the requirements of the Establishment Clause, and if we were to do that, presumably St. Isidore, or at least chartering St. Isidore, would be unconstitutional. On the flip side, if we think of it as a private entity, it's not a state actor, well then we end up down the Trinity Lutheran, Carson v. Macon line of cases that Mark already alluded to. Once you open up a funding program or a program to a wide range available to all private entities, you can no longer say, whether it's discrimination based on status or use, whatever it might be, you can't say, well, but not for religion, or but not for sectarian institutions. And maybe that's right, but let me just say some things to kind of mix it up a little bit. You know, one of the things that's interesting is, right now, I don't think this was the case, we were just chatting about this. I don't think this was the case maybe 20 years ago, but right now we know a lot less about the Establishment Clause than we do about the Free Exercise Clause. Establishment Clause doctrine has kind of stayed, I don't know, relatively stagnant for 20-something years, and then we were given, maybe the Establishment Clause got spiked. I'm not sure how to do the football metaphor here from the Kennedy v. Bremerton, that's the coach who's praying on the 50-yard line. We were told, not that the lemon test that we had used for so many years that prohibited certain kinds of purposes and effects, that it was being overturned, but it had been overturned. You didn't know it, but it happened. We can't tell you when, but we're sure it happened. Okay, great, fantastic. So as a result, we're in like a little bit of, I don't know, Establishment Clause purgatory. We don't know I'm gonna stop. We don't know exactly what the rules are. So I want to say a little bit about each side of the ledger, and then maybe I'll kick it over to Michael. On the Establishment Clause side of the ledger, we're told that lemon is no longer a good test. What was lemon about? You couldn't have, you had to have a secular purpose under the lemon test. Some sort of government action had to have a secular purpose. Its effects couldn't advance or inhibit religion. It couldn't have excessive entanglement. It sounds like maybe excessive entanglement remains, oral argument on Monday. Well, I mean, some justices think it doesn't exist, but it probably still exists. But the purpose and effects parts of lemon, those seem to have been, to some degree, jettisoned. And the puzzle is what's left of the Establishment Clause right now. One thing we know for certain from the Supreme Court is government can't engage in conduct or behavior that's religiously coercive. That we know for sure. And the big question right now, I would say, on the Establishment Clause side of the ledger is there anything besides coercive government conduct that is still prohibited? Some justices over the last 20 years have said, no, that's really all that ought to be left once we peel back the lemon test from the early 70s. If you take this view seriously, and some justices currently on the court certainly take it seriously, you do begin to puzzle as to whether we go down the St. Isidore is still a state act or a public school, why it would still be unconstitutional. I say this even as I have this gut instinct that it must be the case that you can't have a religious public school. And yet, people would choose to go to St. Isidore. It doesn't seem inherently coercive in terms of the choice the students make. In addition, sometimes in a post-Lemon world, we still say that government can't have a denominational preference. This is from a 1982 case, Larson v. Valente. Of course, that a case that the court almost never cites in its Establishment Clause jurisprudence, but there's no reason to think that there's any preference being shown in St. Isidore. One might assume that, I don't know, if somebody else came with similar papers from a different faith community, they would receive the same treatment. And maybe you might say to me, at certain points in time, thinking 1994, Kyrgios Joel v. Drummond, the Supreme Court has said, well, if you're giving out interesting things, let's call it, unconventional things to a particular religious entity, we need some sort of upfront assurance that you'll do it for all similarly situated faith communities. And maybe you might think to yourself, the court might say that here, but the court really doesn't make this argument particularly frequently, and the current court seems unlikely to. And when you puzzle about it this way, it's hard to do, I would say with precision, the Establishment Clause math, even if you go down this St. Isidore is a public school line of reasoning. And one thing that might happen, if indeed the court does go down that path, we might get some significant clarification as to what the court thinks about the Establishment Clause. I mean, it would be incredibly helpful, given that if you take seriously this, all that's left is coercion to the Establishment Clause. The court has been saying some strange things then for the past 10 years. Note the court has said over the past 10 years multiple times that government behavior that denigrates religion or that proselytizes violates the Establishment Clause. But if we are really living in a only coercion world under the Establishment Clause, why not? I can denigrate somebody without coercing them to do something. I can even try to proselytize without forcing them to do anything. And so one wonders what exactly the Supreme Court has in mind for the Establishment Clause going forward, and maybe St. Isidore, if they go down that path, would help clarify some. Okay, let me leave that aside. That's the Establishment Clause side of the ledger. On the free exercise side of the ledger, puzzles once again lurk. There's a simple way to view all this. Yes, this is Trinity v. Lutheran, Carson v. Macon. These cases that say you can't have these sectarian exclusions anymore. But courts have been at certain times still reluctant to, I would say, apply these cases seriously. I was involved in some litigation out in California. California has a law that says under the Individuals with Disabilities Education Act, California can contract with non-public schools, private entities, and they'll contract with them in instances where they have a particular student in a public school that they can't provide an appropriate education to, what they call a FAPE, a free appropriate public education. And so they'll contract with a private school, but they have a rule that says you can't become a state-certified non-public school if you are sectarian. And one of the things that came up in the district court that originally rejected the constitutional claim, or told us we are unlikely to succeed on the merits with respect to a preliminary injunction, the court said that, again, this is contracting. Maybe contracting still gets treated differently. This isn't just some sort of program that's provided, but it's the state trying to figure out who it wants to contract with, or it's the state trying to figure out who provides a public education, something akin to a public education. And we might have thought that these arguments had been dispensed with in cases like Carson v. Macon, in cases like Trinity Lutheran, but lower courts haven't perfectly gotten the message, let's say. I was just mentioning before, I have this event tomorrow where, in cooperation with Notre Dame's Religious Liberty Clinic, we are launching, I wear multiple hats. When I say that, it's funny because I wear a yarmulke and I wear one hat. I also wear multiple hats. Okay. Let's leave that aside. Okay. So I do work with the Union of Orthodox Jewish Congregations of America, and the Orthodox Union for short, and Notre Dame, some other organizations have come together to put together a website of all the various kinds of state laws that still exclude religion. As best we can tell, there are close to 500 of them. And you can imagine litigating one by one is exhausting. More exhausting than flying back and forth every week from Los Angeles to Yale Law School. So, what will be on that front? Whether or not one might expect, if we do go down the free exercise line of logic, because St. Isidore is used as a private school, maybe we'll get some cleanup on this front, meaning maybe the court will explain or detail the kinds of arguments, the kind of attempts to find trapdoors in the Carson doctrine that are no longer available. It would be a strong thing to do in this case, because if in this case the free exercise clause applies, certainly in a wide range of other cases, the free exercise clause would apply to prohibit the religious exclusion. And I think in that way, that might actually be, in some ways, the biggest practical payout of St. Isidore. If it turned out that the likelihood that you needed to actually litigate one by one, state by state, was no longer necessary, but instead the Supreme Court explained quite clearly what the contours of the Carson doctrine are, meaning that you can't exclude religion from a government program, and all the various reasons about this is a contract, or this is just, we're trying to provide a public education, or, you know, the standard move, taking the legal exception and making it part of the rule. It's not that we are saying religion is not part of the program, it's just the program itself doesn't cover religion and other kinds of legal sophistry. Maybe actually the court could do quite a lot with St. Isidore, also on the conventional side of how the free exercise clause might go, and maybe with that I'll kick it over to you.
Great. Well, let me say thank you also to, as always, to Mark Movsesian and to the Mattone Center, to the Mattones for their generosity, and to St. John's Law School. It's always great to be here in New York doing programs with this tremendous center. So I've done a lot of these kinds of panels and radio shows and media and things like that around this case, and I'm still not sure, a month out from oral argument, if it's a hard case or an easy case, because I think there are a lot of easy issues in the case, and I think there are a lot of hard issues in the case. So let me just say a few things maybe to prime some of the discussion. So one thing I think is worth underscoring is the kind of arc of the Establishment Clause that we've already discussed a little bit. I was actually teaching some Establishment Clause issues this morning in my First Amendment class at Villanova. And I said, you know, if we were sitting here in 1985, this class would look very different. We'd spend a lot of time talking about maps and field trips and bus fares and things like that. And this whole effort post-Everson, really through the 1990s, to police the kind of boundaries of funding that can go from the government to religious schooling. And a set of arguments, people like Philip Hamburger at Columbia and others were successful in persuading the scholarly community and also the bench that whole way of proceeding with regard to the Establishment Clause was a mistake. And that it was relying on bad history, bad understandings of the Establishment Clause. And it went along with also, I'd say, a complete collapse in the kind of defensive use of the Establishment Clause by government actors who were kind of overactively kind of engaging in separationist behavior. So this actually was an issue in the Kennedy versus Bremerton School District case, which was the occasion for Justice Gorsuch saying that we long ago abandoned Lemon. But you saw it as far back as 25 plus years ago in cases like Rosenberger, the Virginia newspaper free speech case, where over and over again the government would defend its action or its barriers to funding something on the basis of the Establishment Clause. And the court has now completely rejected that view. And also just with regard, as I say, the funding issues more generally, I think the culminating watershed moment of that arguably is 2002 in the Zellman case that held that vouchers were constitutionally permissible, but even maybe a little earlier in cases like Agostini, wanted to pull a New York case out here, where the court said that barriers on special ed teachers being funded by the state and working in private schools, religious schools, was constitutionally permissible. So I think that's the kind of the Establishment Clause piece that's interesting here, and this is kind of the latest iteration of that after the Trinity Lutheran Espinoza-Carson line, where you see the argument that the state's invocation of Establishment Clause doctrine to oppose, and you see this in the Oklahoma Supreme Court's opinion actually, to oppose the provision of funding to religious schools as a kind of all or nothing matter has completely gone by the wayside. So that's kind of one chunk of the argument that I think it's important to emphasize here. There's also at the same time the whole, which we haven't talked so much about what are charter schools. So 46 states now have charter school programs, as well as the District of Columbia. Started in my home state of Minnesota. in the 1990s. And in some ways, and it's interesting the history here because it's kind of coterminous with the Zellman case in 2002, in some ways charters were kind of compromised between the traditional full-on school district, government-run public schooling model and a voucher program, where you just kind of have a complete kind of free market approach to the provision of education. Everyone gets to go, money following students, not following school districts and so forth. So charters were envisioned, as I understand this history, as a kind of a halfway compromise between those two models. But they vary considerably state to state in how they're created, how they're governed, what kinds of entities can be partnered with. So in Pennsylvania, for example, I happen to know that the first round of approval usually goes through the local school district. You go to the school district and say, hey, I'd like to start a charter school to, for arts or STEM, classical schools, whatever. And the school district gets to decide whether or not to give you the charter or not. There's also, as I understand it, an appellate process. You kind of go to the Commonwealth and go to the statewide charter level. Oklahoma, interestingly though, and I think this is an important aspect of the case, it's a statewide board appointed by the governor for both brick and mortar charter schools and in this case for online charter schools, different boards, that has independent authority to grant charters or not. And in the Oklahoma case, I think it's almost dispositively the case that the government has partnered with nonprofit entities and even in one instance a for-profit corporation that runs an online charter school, and the government, the online virtual charter school board in Oklahoma has granted them a charter as well. I think that makes the state action argument here very difficult for the government to prevail on. Just a footnote, actually, the Oklahoma local politics is kind of interesting on this. Originally, the Republican Attorney General of Oklahoma told the charter school boards, hey, after Carson versus Macon, you can no longer deny charters to religious applicants. Then they got a new Attorney General who took also a Republican, who took a new position though, saying that, oh no, this would violate the Establishment Clause, because if we allow Catholic charter schools like this, we'll have to allow something like a Muslim charter school eventually. To which I answer, yes, absolutely, right? If they meet the criteria, and if they abide by all the state's accreditation and other requirements that the state might want to impose, it seems to me that other religions can participate just as well. So, but it's interesting, the point there, of course, that the Attorney General took advantage of the provision in Oklahoma law that he can then file an original action in the Oklahoma Supreme Court to challenge another arm of the state government in its creation of a charter school in that context. So we've talked a little bit about the state action issues here, and I do think that one of the important points here that is being made in the litigation is that the labels are not dispositive. That the fact that the state calls them public charter schools, or the fact that the Oklahoma Supreme Court says, well, these are public schools under Oklahoma law, I don't think that's dispositive because, as the dissent in the Oklahoma Supreme Court said, that risks putting form over substance. And there are lots of cases in the state action doctrine, which we could talk about for hours and hours and hours, in which the court has gone back and forth on this issue. So I took Amtrak up here today. 25 years ago, the Supreme Court, in a case called LeBron, decided the question of, is Amtrak a state actor? Because Amtrak, for First Amendment purposes, for speech purposes, said, no, we're a private actor, so we can decide who gets to put a billboard up around our stations and so forth. But interestingly, the Supreme Court said, well, no, if Congress creates the corporation and if all the members of the corporation, the National Passenger Railroad Corporation, are appointed by government entities, that's a government entity, you're subject to the First Amendment. So the labels are not dispositive with regard to the state action issue in a kind of wholesale way. And so there again, I think the Oklahoma Supreme Court and the Attorney General are in hot water here because they're saying, well, these are public schools and this is the provision of public education. But if it's an outside, independent, nonprofit, or as I said in one instance, for-profit entity that the government's contracting with, it doesn't turn it into a state actor. Government contractors, by virtue of the Pentagon contracting with an armed, aerospace manufacturer, doesn't turn that actor into an arm of the government just by doing that. And I think that's the analogy in this point here. And then as Michael and Mark pointed out, then I think you run headlong into the Espinoza-Carson line there, which is, again, that when you have the provision of funding and programs available to private entities, the government violates the Free Exercise Clause if it excludes religious participants from participation in those programs. I think that's, and even I noticed the response brief 2 days ago, filed by the state in this case, acknowledges as much, says we don't have any dispute. Of course, it'd be terribly unconstitutional if this were a genuinely private partnership program to deny religious participants in the program, but they're not, because they're public for all these reasons that I think ultimately are mostly unpersuasive. So I do think that in the end, the harder questions, I think, are some of the Fed courts questions, actually, about the extent to which the Oklahoma Supreme Court's determination of some of these points of state law are controlling. I think the chartering provisions are very important too, because as I say, it varies a fair bit from state to state, and we have so many different ways in which charters can be recognized. And just in the education policy space, I think it's interesting, because on the one hand, you'd have a model that charters, the whole point of charters is to get educational options out from under the school districts, right? To get parents and kids into options where they're not accountable to only what the school districts will provide, what the teachers' unions want to do, and so forth. And so that's the kind of one avenue of it. But of course, the other avenue is that they can't be totally independent either, and they have this kind of government contracting component to them. Just one last issue so we can open up for discussion. I do think it's a hard issue in the case that Mark Movsesian flagged about the funding formula. So Zellman, one of the maybe arguably load-bearing walls in Zellman in 2002 was that when Ohio gave the vouchers to the parents and they exercised their choice to take the voucher and use it in 80+% of cases to go to religious schools, that the independent choice of the parents to use the voucher in that way severed any Establishment Clause problem with regard to the use of it. And Chief Justice Rehnquist actually goes on for several paragraphs about the significance of the independent choice. There's a hard issue here about, well, what about in this case? Does that same conceptual framework with regard to the constitutional permissibility of voucher programs apply in the charter context as well? The argument on behalf of St. Isidore's is that there's still choice going on. That if no one signs up for St. Isidore's gets no money. The funding formula is based still on parental choice. Granted, the nexus though, or even the funding mechanism, is a tighter connection from the decision of parents to send their kids or to have their kids go online to St. Isidore's and the provision of the government aid than it was in the cases like Zellman, where a lot of the argument was that when there's this kind of intermediate step of the independent choice of the parents, that cures any Establishment Clause problem that we might have. So I think there are a lot of issues on the ground here. I hope we've primed the pump for discussion here. I do think that St. Isidore's is likely to prevail in the business of prediction, because often the Supreme Court doesn't take these cases just to tell the lower courts what a nice job they did. So I think they're likely to prevail, but as is often the case, how the opinion gets written, what kinds of avenues they want to go down on the state action issue, on the establishment issue, and on free exercise, I think are still very much in doubt.
Okay, great. So thank you so much. We'll open it up for discussion now. I want to begin by asking a couple of questions, one of each of our panelists, the questions that were stimulated by their talks. First to Michael Helfand, when you were talking about the Establishment Clause test, you were highlighting that it's the coercion test, which is still out there. The court has made clear that whatever the test is, even if Lemon is gone, the state cannot coerce people into religious practice, and coercion then becomes debatable. Is that, gun to the head? Is it fine? Is it criminal imprisonment? Is it peer pressure? There are some cases that suggest peer pressure in schools can be kind of coercion. But there's another aspect of Bremerton, not about coercion. Bremerton is the case that announced that Lemon was overruled. We didn't see it happening, but apparently it happened. Lemon has been overruled. It's the history and tradition test. And that is also apparently the test going forward. And I wonder how that would cash out in this case, because we don't really have a tradition of charter schools in the United States. I think that's a fairly new thing. And we certainly don't have a tradition of state-funded religious charter schools. So, that would be my question to you, is if the court means what it says about history and tradition, how would that cash out here? And for Michael, I want to push back a little bit on this last point about funding. It is true, it's not just Zellman. It goes all the way back to Everson, the first case in which the Supreme Court said the Establishment Clause applies to the states at all. It was the case involving bus fares, and the court said, look, this is, bus fares are going to parents, and parents get to decide. So the idea of individual parental choice goes back all the way. And here to say, well, there still is parental choice because after all, the parents decide whether to send their kids to St. Isidore's or not, that's also true of public schools. The parents get to decide whether to send their kid to a public school or a private school. So the idea that that makes it all better, it's not an Establishment Clause violation because the parents can ultimately decide whether to send the kid or not. I mean, I see that, I understand that, but I'm not sure that's a distinction that would really get past this idea. To me, it does seem very significant that money is going directly to St. Isidore and not going to a parent who then gives it to St. Isidore. So those are my two questions for our panelists.
I kind of want to answer your question. How does that work? Can we trade? I don't know what to say, history and tradition. I mean, we don't even have a history and tradition of public schools really from the founding period, so
That's
it's
a nice
like
point, too.
we don't seem to have much of anything, so good luck to us. What might I say? I'm working on a project right now with Mark Storsley, I assume you're both, and we've co-authored a paper.
If you want to work in law and religion, you have to be either named Mark or Michael.
I was originally called Avi. That's my middle name. Like, that's not going to do. Try again. Okay, good. So we have a theory. I don't know if it's a great theory. We've written like 30,000 words about it, so it better be an okay theory. And we have this view that maybe you have to go beyond coercion, a history and tradition test, or at least a principle consistent with founding era history might not only prohibit coercion, but would also prohibit what we call government conduct whose objective purpose is to induce conformity. This goes back to kind of the Acts of Uniformity from England and the desire to move beyond that. President Washington's proclamations, where he changed the language so as not to encourage people, encourage citizens to fast and pray, but dialed back the language a little bit of the proclamations in order to express, I don't know, something different that was less encouraging and more matter of fact. We've built a theory based on, there's not a ton of history, but maybe enough to say that there is this anti-conformity principle that you could extract from founding era history. So not just coercing you, but to use the language of Zorak, Zorak Clause 1952, to force or persuade. There is this language that you see that creeps up again and again in many cases, that it's not just force, but also persuasion on the part of government that's a problem. And if this were true, it would explain a lot, at least. It would explain some of the things I mentioned before, like why does the court think that proselytizing and denigration is a problem? If you buy into this anti-conformity principle, you might say because to denigrate is to persuade, to proselytize is to persuade, and that might just explain a whole bunch of stuff. So maybe that's what a history and tradition test would get us, or at least a history and tradition test that's somehow refracted through the case law, even in the passing years. Even in Kennedy v. Bremerton, the court's still using this force or persuade language from Zorak, and you might say to yourself, if it's just coercion, like, what's the persuade issue? That's not Justice Scalia's like threat of legal penalty. The court seems to have something else still going on, and maybe that's at least the beginnings of an answer to the question.
Yeah,
I want in on his question.
Sure.
On the funding question, I think there will probably be a lot of discussion of this in oral argument. If the question is how much money does the school get in a voucher program or in a charter school context, the answer to that question will depend on parental choices, right? It'll depend on, as I say, if no one signs up for St. Isidore's online charter school, St. Isidore's won't get any money. The formula is based on the number of kids who choose to go to the school. That's the same in the voucher context, right? The amount of money that the private schools, including religious schools, get in a voucher program depends on whether or not parents are deciding to use the voucher in that context. So that's why I think charter schools exist in this kind of gray zone between. They're not exactly voucher programs, of course. That was in some ways, the whole impetus to the charter movement was not to go the voucher route in many states. And they're more like government contractors in my view, and as government contractors, the amount of money that they have available to them will depend not on the government's decisions, because all the government does is it creates the entity and says, yes, you, on a neutral basis, you can participate in this program, and then the funding formula depends on parental choice. That's the best answer I have for that.
Yeah, this is bad news for everybody because I was teaching Mitchell v. Helms and Zelman v. Simmons Harris this morning, so I'm ready to go. And in my class, how many students here want to hear the craziest thing that I do in my class? We read almost every single Establishment Clause case from 1947 through 2024, not excerpted and in chronological order. So it's a beast, and Mitchell v. Helms is a beast. But one of the things you learn about Mitchell v. Helms in the plurality decision, there Justice Thomas in Mitchell v. Helms says he thinks per capita funding is perfectly fine. The form of it doesn't need to take a pit stop. And the
It's a case about computer equipment.
Including computer equipment, other kinds of equipment. It's actually really interesting because it's the first time it seems like Supreme Court justices encountered a computer. They're discussing what does this thing do? Can it do whatever it wants? Okay, let's no more. So, and there, you have a plurality of justices, and the plurality of opinions also authored by Justice Thomas that are of the view that per capita funding programs satisfy the independent choice doctrine. But there are only 4 of them at the time. Justice O'Connor with Justice Breyer, they don't buy the per capita rule. They say, per capita funding, no, it needs to take a pit stop. And when you boil down the argument for why it needs to take a pit stop, meaning when I say pit stop, with the family that has the money, then hands it over as opposed to just a formula, I think Justice O'Connor's strongest argument is an endorsement argument, that it starts to look like, that's her claim, at least in her concurrence in the judgment, that the per capita doesn't work because if the money just flows directly, we have an endorsement problem. But if that's really the argument, it's been repudiated. Because in Kennedy v. Bremerton, we were told the Lemon Test and its endorsement offshoot are now off the table. So I don't know, if I'm doing the math, it sure looks like per capita, at least the bits and pieces we have in the doctrine. I confess already that we don't know much, but there are strong indications that per capita should satisfy the Establishment Clause. I'll say one more thing. What was with Trinity Lutheran v. Comer? I mean, that's just direct funding straight up. There's no independent choice. That's just money straight to the church. It's a church and school. When the Supreme Court there, this was a program for if you use tires, if you used tires as part of some sort of nonprofit, plan. Here you had a school that wanted the bouncy bounce on the playground. They wanted to use used tires. They used used tires. The state of Missouri gave them the grant for it, and when they're about to give them the grant, they say, "Oh, you're a religious institution. Just kidding. Give us some. We can't give you that money." And the Supreme Court ultimately finds in favor of Trinity Lutheran Church and School that they have to be included in the program because it's available to all other private entities. But there is this puzzle. It's direct funding, and nobody seems to care. When the Supreme Court does its Establishment Clause analysis, here's what it says. It says, both parties agree this is permissible under the Establishment Clause, period. And the dissent is like there's supposed to be doctrine here, but we don't get any. But if you're now looking back at precedent, it seems like we have at least one direct funding case on the books. So one wonders if there's really this kind of strong need even. Now, I don't want to overclaim. In Carson v. Macon, which comes after Trinity Lutheran, the chief multiple times references the independent choice doctrine. And that was I think, the emphasis was a surprise given that Trinity Lutheran was direct funding. So I don't know if we know, but let's just say doctrinally, if you're doing the Establishment Clause math, there are lots of good reasons to think that per capita funding is going to be per capita formula is going to be perfectly fine under the Establishment Clause.
That's a very fair point. Okay, so we have time for a couple of questions. So I'll open it up to the audience. I guess, Ricky, maybe I'll give you the mic. If anyone has a question, then please speak into the mic, and we'll use this mic here.
Just break the ice. John Barrett, thank you to each of you. This is a wonderful education. A math question. Is this a short court? Is Justice Barrett recused from this
Yeah, it's a good point.
case or no?
Hang on.
She recused herself from the cert petition, you know that, so we don't, I guess we don't know if she'll sit in the case, but presumably.
I don't know, that's good. So the question is whether Justice Barrett, who I didn't realize she had recused herself from the cert petition, is that because of the Notre Dame connection, maybe?
You should, you know.
Oh, she didn't say. So that's a good question, I just don't know. So it could be, an 8-person court. They could still get a majority.
Sure. I've been operating under the assumption that, I didn't even think of that distinction, that her recusal from the cert petition meant that she would be recusing herself. That'd be quite a puzzle if she didn't at this point. I don't think I'd be able to figure that one out.
Well, I have a question, I guess I'll ask. So in the Trinity Lutheran case and the school busing case, it seemed like the funding was going for things that wasn't direct education, religious or not, but it was going for getting kids to school or safety, and I didn't read them in a while, but it seemed to be like they spoke about these things being necessary for kids and that everybody else got it. Do you think that there's a difference, and in this case, it's about the actual, like, you're paying for them to teach the students and they're teaching them religious material?
I think the water is already under the bridge for that in cases like Zellman, but certainly in Carson, where the state's objection was to the fact that the money was being used for religious education, you know, in sectarian, which is a loaded word, schools, and the court has rejected that.
So I think that's an excellent question. To my mind, it does seem different to say, not only is it going to directly to the school, and I give credit to Michael Helfand, I actually had forgotten about Trinity Lutheran, that it was for tires, right? And I think, well, what are the parents gonna do with tires anyway? Of course they give it right at school, but it's funding, I understand that. So, okay, it's funding, okay, but that's not for education. This would be direct funding to the school for the purpose of Catholic education. And so that distinguishes it from Carson, where it was to the parents who then chose Christian education. And I just don't know, will the court look at those two factors put together and say it's still okay? I don't know, maybe. That would be a real bridge being crossed if they did that, it seems to me.
I don't have, I think, a ton to add. I do think the action on this is Mitchell v. Ellis. I really do think that is where you get an express debate over the pit stop issue, and you have really on that issue, you have a 4-2-3 decision. So I don't think we know for sure. I can tell you as a practical matter, I've certainly operated under the assumption that per capita, that's just dealing with clients, that per capita is a very strong argument. I'll give you an example. We had, maybe I shouldn't, let me see what I can strip out of this one. Somebody called me and said, listen, we have, okay, hey, okay, here's how this goes. So New Jersey has this program where they would get, school districts could get funding for nurses. And they would get that funding, they would pass it along to schools to help defray the cost of a school nurse. Seems like a good thing to do. But the school district, I hope I'm remembering the facts correctly, the school district could only contract with one agency to provide the nurses. Why was that a problem? So somebody called me and said, we don't love this statute. I'm like, why? It sounds lovely. They said, here's what happens. Because the school district can only contract with one agency to provide nurses, when the schools itself go to the agency to request a new employee, what happens is they are asked to pay some sort of exorbitant processing fee. Because it's a monopoly, and that's what you do when you have a monopoly, you just start jacking up the price. And as a result, really what they were doing was they were being able to claw back a lot of the government money that was really supposed to help the school, but actually the intermediary was dealing with it. So I said to myself, I have a great idea. What's the great idea? The funding program should be changed. How should we change it? We should make it, say it with me, per capita, right? We should cut out the middleman to avoid this is gonna sound harsh, grift of the middleman, right? And that way it would be much better. And then people said, wait a minute, are you allowed to do middleman? And I said, Mitchell v. Helms. So I think the per capita stuff is a really interesting question, because if you did it that way, you wouldn't have to avoid the contracting issue, just have the formula based on the number of students and redo the whole, there are other statutes that work this way. So I actually think, not only in principle does the per capita thing actually make a lot of sense, not only do I think there's a lot of precedent on that point, but I also think practically it actually makes a big, big difference to make sure that these kinds of funding programs work effectively.
Otherwise, yes, there's one there.
Hi, thank you so much. If the court delineates what makes a public charter school and what makes a private charter school, do you think that states will want to model their charter school programs to make more private charter schools that are allowed to fund religious schools?
Hang on.
Well, if this case goes the way I suspect it will, and normally I want it to go, I think they'll be required, at least depending on how the charters are created by the states, the contracting process, they'll be required to extend that benefit to religious participants. Now again, this is all part of the kind of the charter school debate at the state level. You could bring all that chartering back under the control of the school districts, but then you're gonna have all the problems that you have with the impetus to create the charter school movement in the first place. We want, the parents want options that aren't just government-run, school district administered programs. So that's the kind of the dilemma I was kind of pointing to, that the charter school movement's participating. It's kind of interesting, a lot of the people who are really on board with the charter school movement, by the way, they don't like the St. Isidore's thing, right? Because part of the I guess the political popularity of charter schools was that, well, they're kind of public schools with a choice, you know. But again, I think that depending on how they're created, if they really are created through a government contracting process, then I think the logic of Carson says you have to allow religious schools into the program as well.
I love the question, because, Michael, I think you'd agree with this, like, there are things that each state could do to increase or decrease the likelihood of a constitutional challenge to their excluding religious charter schools from their programs. Like, whatever the court says, it'll say a whole bunch of words, and you know, states could stare at the words and say, oh, wait, you left me a little room here, a little room there, I can increase oversight, increase regulation, do a couple of this or a couple of that. And I take the question to be like, well, so are the states gonna look at it and try to parse it and say, therefore, we're going to change it, we'd like to change our program to make sure we have to have religious charter schools? Or will states say, no, let's do something so that maybe when the next constitutional challenge comes, we don't get Oklahoma or something along those lines? And I suspect, and I'd be curious what you think the answer here is, I suspect different states will do different things. But I do think we'll see action. Like, I think states will make changes as a result, because it's a jurisdiction-specific inquiry, so that's my guess, but you know more about this than I do.
And there's a big looming issue in the background as well of your question about what conditions can the states put on the charter schools. We saw in Maine, after Carson versus Macon, they imposed a bunch of non-discrimination requirements that effectively meant that a lot of religious schools couldn't participate in them. And those are being currently challenged under the unconstitutional conditions doctrine. Now, the states run into problems with, you know, if they say impose non-discrimination requirements in hiring with regard to the ministerial exception and things like that, but can you impose non-discriminatory requirements in admissions? What kinds of accreditation requirements can you impose? And again, that all falls into this unconstitutional conditions doctrine, which is famously a complicated area.
Yep. Okay, I think we have time maybe for one more question, if anyone has one. Okay, so otherwise the case is submitted.
Can I ask Michael one more question?
Oh, okay, sure. Not yet.
Why not? I've got him here. What do you think about, because I know we disagree a little bit on the unconstitutional conditions doctrine. I don't remember exactly why, but what do you think about the requirement that charter school, let's say St. Isidore goes both as you predict and as you prefer, and as a result, you do have this requirement to accept anyone who applies. How would you work through the unconstitutional conditions now? Is that an unconstitutional condition?
And I should say that's being litigated right now in the First Circuit, that exact question.
Yeah, I think it's hard. I think that you know, Carson says, relying on a line of as we talked about it in Notre Dame a few years ago, the line of free speech case that says, well, because Maine and Carson said, well, that the program is non-sectarian education. That's what the program is, so that's a lawful condition for us to put on people participating. And Chief Justice Roberts invokes this line from an earlier case, says, well, you can't kind of redefine the scope of the program in such a way to subsume the forbidden condition into the program, because that would make the First Amendment something like mere semantics or something. So the question is, what kinds of leeway does the state have then to kind of define what a charter school is? I do think that it's on probably stronger. I think in the end it comes to a hard question about what are the state's most important interests in delivering education, including through charter contracts. Does that require, for instance, that the charter schools have open admissions policies to whoever wants to come? Or does it, can they also impose hiring requirements? I think the hiring thing, as I said, I think that's harder because in the religious context, you're gonna run into some ministerial exception problems if the state's imposing those limitations. I think on the admissions front though, and some of the non-religious curricular aspects of the program, I think those look like those can be defined within the scope of what the state's interests are in a way that doesn't run afoul of any constitutional requirement.
Okay, so I think we should close there. I want to thank again our panelists. I thank the audience for coming and the JCLS for doing this. And I can see, but you can't. There's food in the back. So please feel free to go get some refreshments, and we'll go happy there.